It's Monday, and that means it's time for another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about the Trans Mountain Pipeline. Cases that should have gone to the Supreme Court of Canada, but didn't. As most people in Canada are aware, there has been a lot of litigation over whether or not certain Indigenous groups in Canada were properly consulted and had their views accommodated in the approval of the Trans Mountain Pipeline project. The Supreme Court of Canada recently refused leave to appeal a judicial review decision from the federal court involving a number of these Indigenous groups who said that they weren't properly consulted or accommodated in the approval process. This was the second time the pipeline case had gone back for consultation and accommodation, and so this was supposed to be them doing it right after they had been told that they had initially done it wrong. And this case raises important issues because there's not only a question about whether there is proper consultation and accommodation involving Indigenous groups in circumstances like this, but also a real sense of fait accompli, in the sense that all of these decisions to approve the pipeline and all of the spending and the hiring and all of the efforts to put the pipeline in place had already been undertaken, the money had been spent, the decisions had already been made, and now they were told to judicially review it and to go back to the drawing board with consultation and accommodation, reapprove the plan with very, very minor and unsubstantial changes. And so this raises the question, was the second judicial review really something that was actually taking into account the viewpoints of the Indigenous groups who were affected by it? Or instead, was it just an exercise in performing all of the necessary steps to reach the desired conclusion, which is of course not consultation and accommodation, but is instead giving lip service to the duty without actually performing it? And this is a unique set of facts, but an important one as we see this area of environmental litigation and Indigenous rights evolve as more projects like this are approved or proposed or are considered by government as we look to different ways of moving energy resources across the country and trying to make things safer and more green, whether it's pipelines or whether it's other ways that are proposed by other groups. Everybody has an opinion on this, and so the Supreme Court of Canada would absolutely have engaged in something that is of national interest and national importance by addressing this case. And because of the unique factual background, it set the Supreme Court of Canada up to comment on what happens when you have a decision maker making the same decision that they've already made against a backdrop of being told that they didn't go about the process of making that decision properly, and how you look for those hallmarks of whether the decision is reverse engineered to achieve the desired result that was the original result in the first place. None of that, unfortunately, is going to be commented on by the Supreme Court of Canada because they refused leave to hear these cases. And the problem that arises from that is that the Indigenous groups that were involved and at the center of the litigation leave the justice system with this issue feeling as though they haven't had their full opportunity to be heard, which, from a reconciliation standpoint, is also problematic. There were lots of good reasons for the Supreme Court of Canada to engage with the disputants in this case and to let their view be heard on the consultation and accommodation and the judicial review of that decision that took place after the original decision, sending it back for a new review. And unfortunately, the Supreme Court of Canada really missed an opportunity to realize those realities that we have to deal with in cases like this. Hopefully it doesn't take another pipeline and another series of judicial reviews and another group of Indigenous people who say that they're being wronged by it to bring this into a situation that makes it to the top court. But until then, we don't know. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.